towards the realization of a peaceful, democratic, and just society has been a very complex and arduous one, but we shall never give up. For decades, political turbulence, social and economic disparities, and governance challenges have tested the resilience of our institutions and the resolve of our people. Vulnerable groups, particularly women, children, persons with disabilities, and the elderly, have borne the brunt of these challenges. In response, the African Union adopted Agenda 2063 as a blueprint for the continent's transformation. Central to this vision is Aspiration 3, which seeks an Africa anchored in good governance, democracy, and respect for the rule of law. As judiciaries, we stand at the very heart of this aspiration. Our courts in all our countries are the interpreters and defenders of constitutionalism and the rule of law. We must be the architects of justice systems that reflect the vision of a continent driven by its citizens and one that commands a respected place in the global stage. The increasing recognition of African judiciaries as key enablers of good governance, human rights, and democracy is a testament to our collective progress. Just a few decades ago, African judiciaries were largely sidelined in matters of governance. The judiciary was seen as a peripheral institution with limited influence. Today, the tide has turned. Judiciary is not a child of a lesser god. Courts across the continent have asserted their role in protecting democratic processes, upholding constitutionalism, and defending human rights. We have moved beyond being passive players as we were perceived decades ago. Today, African courts actively enforce constitutional limits on power. They protect individual freedoms and provide the much-needed checks and balances that are crucial to our functioning democracy. Across the continent, courts routinely hear and determine disputes ranging from presidential election petitions, disputes regarding the constitutionality of constitutional amendments, and those related to enforcement of climate justice and socio-economic rights, among others. Therefore, it is clear that African courts are consequential players and have a role in shaping the future of the continent with respect to the realization of Aspiration 3 of the Agenda 2063. Honorable judges, jurists, ladies and gentlemen, in my reflection, in order to fulfill our duty under Aspiration 3 of Agenda 2063, African judiciaries ought to play a number of key roles. One is the purposive interpretation of laws. Our courts ought to interpret laws in a manner that promotes the realization of Aspiration 3. Our true north, in all cases that come before us, should be to interpret laws in a manner that enhances rather than distracts from the goal of promoting the realization of good governance, democracy, rule of law, and respect for human rights in the continent. Number two is the protection of human rights. Our courts have the primary duty of protecting human rights and fundamental freedoms. Governance, good governance, democracy, and socio-economic development that is built on the foundation of respect for human rights and freedoms. In other words, respect for human rights dignity should be central in all our decisions. By the effective discharge of this function, our courts will be playing an invariable role in securing societies where human rights and democratic values are enshrined in political and socio-economic discourse. The third reflection is a robust judicial review process, which is a fundamental power given to the judiciaries. Judicial review is essential to entrenching good governance, the rule of law, and respect for human rights, because through this exercise of judicial review, the power is given to the judiciaries to check constitutionality and legality of laws and other government actions. In this way, courts will curb the potential for abuse of power and authoritarianism. The fourth reflection on this Agenda 3 is the enhancement of accountability. Accountability is a cornerstone of a peaceful and secure African continent where citizens enjoy their rights and they are able to realize their potential. I heard many speakers speak about corruption, which is endemic in our societies and which we must speak to as we speak about accountability. Through promoting accountability in exercise of power by government institutions, our courts can ensure that government is answerable to the people. This, in turn, contributes to people's trust in government institutions. The fifth reflection is going upstream to promote social harmony in our communities. For far too long, African judiciaries have positioned themselves primarily as downstream actors, intervening only after grievances have escalated into full-blown disputes. However, time has come for us judiciaries to shift this paradigm and adopt a more proactive upstream approach in the judiciary social transformation through access to justice. The blueprint that is guiding the judiciary, we call ourselves connectors and facilitators of our communities and of our people. Instead of waiting for conflicts to land in our courtrooms, our judiciaries must engage more actively with our communities as connectors and facilitators to identify and address the root causes of conflict before they escalate. And to achieve this, we must strengthen our connection with the people that we serve. I think in East Africa region, we call this forum the court user committees, which serve as a vital platform for courts to interact with the public, understand their justice needs, and collaborate on solutions that are both timely and effective. These committees can foster ongoing dialogue between the judiciary and the community members, allowing us to be more attuned to local concerns and grievances. Additionally, African judiciaries must embrace and promote what we call here in Kenya the door-to-door approach to justice. This means offering a variety of pathways to resolve disputes. We've come to realize that the formal justice system, the courtroom, is not the only place where justice is found. There are other forums, including mediation, conciliation, alternative justice system, what we call in Kenya AJS, traditional justice mechanisms, which have long been embedded in our cultures. These forums offer valuable methods of conflict resolution based on communal dialogue and restorative justice. These approaches not only alleviate the burden on formal court systems, but also promote deeper, more sustainable social harmony by addressing underlying issues rather than simply adjudicating the symptoms of conflict. By actively engaging upstream, African judiciaries can help foster peace, prevent disputes, and ultimately contribute to more cohesive and harmonious communities across the continent. This shift will transform our role from being mere arbiters of disputes to becoming enablers of lasting social transformation. My dear colleagues, to conclude, we have to continue playing these critical roles. Certain preconditions must be met to ensure that our judiciaries are well equipped to deliver on their mandates. Let me touch briefly on 3 of these prerequisites for the judiciaries to remain independent. One is our ability to protect the rule of law and human rights, which hinges on our independence. Unless we are independent, we cannot be able to pronounce ourselves against the powerful and the mighty. We will always be emasculated. Judges, judicial officers must be free from external pressures, political interference, and undue influence. In addition, financial independence is equally vital. Without adequate budgetary resources, judiciaries are hamstrung in their ability to deliver justice effectively. Therefore, we must join hands to champion for adequate budgetary allocations and autonomy by judiciaries in managing their budgets. 2, impartiality and objectivity. Courts must serve all citizens impartially. The court is for all. The essence of judicial power is not to serve the interest of any group, but to protect constitutionalism and uphold justice. Objectivity in adjudication fosters public confidence in the judiciary. We must engender public trust and confidence. Ultimately, the judiciary's strength lies in the trust and confidence it enjoys from the public. Without the pass or the sword, courts rely on public confidence to enforce decisions. We have no money to buy people to come to our meetings. We just have to rely on the confidence the public has on us to discharge our duties. If public trust erodes, so does the legitimacy of the judicial system. Therefore, we must strive to enhance transparency in the way we decide our cases. We must be fair and accountable in all our judicial processes. Lastly, we find ourselves at a pivotal moment in Africa's development, where we must answer the call of our people for a continent that is anchored in democracy, respect for human rights and justice. Agenda 2063 is not merely an African Union initiative. It embodies the collective aspiration of the continent, our continent which is yearning for progress, our continent is yearning for peace, and our continent is yearning for prosperity. So as African judges and jurists, we bear a profound responsibility to safeguard and promote the principles enshrined in our constitutions and laws. Our task is to ensure that Africa's transformation is built on the foundation of the rule of law, with judiciaries that deliver justice fairly, impartially, and with integrity. This summit, therefore, offers us an invaluable opportunity to exchange ideas and learn from one another. We are going to build collaboration that will help us in shaping the future of governance of our continent. Through our shared knowledge and experience, we can collectively advance the cause of justice and strengthen the rule of law across Africa. And with these remarks, dear colleagues, it is my distinct honor and privilege to declare the 2024 All Africa Judges and Juries Summit in Nairobi officially open. Thank you for your attention. God bless you, and welcome to Nairobi once again.
For your remarks, and that brings us to the end of the opening ceremony for this summit.